taking care of their compliances under other laws, and they do not place as much emphasis on employment law compliances. Their mindset is that if and when the issue arises, we'll tackle it along the way. But taking preemptive steps is something that very few organizations do. So that's one particular statute that we discussed. The other statute that tries to ensure gender equality at the workplace is Maternity Benefit Act. Now, this is a remarkable statute. You will see that even advanced jurisdictions like USA do not have the kind of rights that the Maternity Benefit Act 1961 envisages. Women are entitled not just to pregnancy related leave, they are also entitled to leave on the basis of other occasions, such as adoption, such as surrogacy, um, such as miscarriage. So there are these events where again women have the opportunity to take leaves. Of course, the leave duration varies. Women get the maximum leave entitlement when it comes to pregnancy, because the idea is not to take leave only for child rearing, but the idea is to also recuperate from the severe physical experience that a woman undergoes when she is pregnant. And that's why pregnancy related leave is the maximum, which is 26 weeks for women who have less than two surviving children. If there are two or more than two surviving children, then women get 12 weeks of maternity leave on account of pregnancy. There is no cap under the law, contrary to what organizations think. I've seen a lot of employer policies which say that women cannot take maternity leave beyond two or three occasions. So that's not right, because the law allows you to take maternity leave for as many occasions as you want. So the only difference, of course, comes in the form of the duration of maternity leave, right? So, like I said, pregnancy is one bucket of leave. Then there are other situations like miscarriage, adoption, etc., which are also covered. For example, for adoption of a child who is less than 3 months, a woman can avail 12 weeks of maternity leave. So it's a remarkable statute, and we often forget the other aspects of Maternity Benefit Act also. For example, the statute also has a very important section, Section 12, which says that when a woman has already proceeded on maternity leave, the employer cannot issue a notice of termination to the woman, cannot terminate her services right away, cannot alter her terms and conditions of employment. So these are very, very critical protections, right? Of course, if a woman is pregnant but she has not proceeded on maternity leave yet, and she has not even notified about proceeding on maternity leave, in that situation, of course, an employer can part ways with a woman employee. But there again, while parting ways with the woman, the employer has to ensure that they are paying for the maternity leave, which is salary for the 26-week period. So they have to pay at least that in case of a woman who is pregnant but has not proceeded on maternity leave, right? So these are very critical, provisions, and really that's how you ensure that employers do not play on the basis of their women fancies. Um, the third statute that I would like to talk about is Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013. Again, a very important statute, and it says that a woman, irrespective of whether she is employed at the workplace or not, can approach the internal committee of an organization in case she has been subjected to an act of sexual harassment in that particular workplace. So every organization that has 10 or more employees has to form an internal committee. And the law also talks about the composition of internal committee, who all can be a part of it. It says that the presiding officer has to be a senior woman from the organization. It also says that one of the members has to be an external member who has got nothing to do with the organization and can apply an independent mind. So that's how an internal committee has to be developed. And again, the law says that uh, the woman can file a complaint of sexual harassment at workplace before an internal committee, irrespective of what the gender of the respondent is. By respondent, I'm talking about the person who has been accused to have committed an act of sexual harassment. The respondent can be a male or a female or even a transgender person. So that, in that sense, the law is gender agnostic. But when it comes to the complainant herself, that has to be a woman. So the law does not deal with sexual harassment faced by a male employee, and that does not mean that any sexual harassment that's faced by a male employee cannot be dealt with. The only thing is that they don't have the statutory protection available. But if a male has been subjected to an act of sexual harassment, they can invoke the code of conduct or the disciplinary policy of the organization and can approach the disciplinary committee if they have been subjected to sexual harassment. The only challenge for them is that they cannot approach the internal committee. Internal committee can take cognizance of only complaints which have been filed by women. Now, someone has asked an interesting question. Are transgenders included under the POSH Act? The answer is no. Transgender persons are not covered under the POSH Act. Yes, if there is a man who has undergone a sex reassignment surgery and is now a woman, and then that person is subjected to an act of sexual harassment, then yes, like any other women, they also have the opportunity of approaching the internal committee if they are subjected to an act of sexual harassment. Now, you would ask what would happen if a transgender faces sexual harassment at workplace. For that, we have a separate statute, which is called the Transgender Persons Protection of Rights Act 2019. That law says that every organization needs to have a complaints officer who will take care of any complaints raised by transgender persons. Of course, in my experience, I have rarely seen organizations developing an equal opportunity policy for transgender persons and appointing senior official as a complaints officer to deal with complaints from transgender persons. So in reality, the enforcement is still very low, but then it's a relatively new statute as well. It got enforced only 4 years back. So we are still seeing organizations slowly taking up their compliances under this particular law. But yes, they do have statutory protection as well. But as far as this 2013 statute is concerned that we are talking about, transgender persons cannot file a complaint there. So again, the law has a bunch of interesting facets. There are timelines throughout the process. I will not get into those timelines, but the important one is that any complaint that has been filed before the internal committee has to be inquired into within a period of 90 days. And both the woman and the respondent will get an opportunity of presenting their case, cross-examine each other, and that's how the internal committee will decide which version is credible and where exactly the probabilities lie. Because obviously, when it comes to sexual harassment complaints, it's often very difficult to adduce evidence, unless, of course, we are talking about conversations exchanged over WhatsApp, etc. But otherwise, if a woman has been subjected to a physical form of sexual harassment, it often becomes difficult to prove that. So in such cases, when there is absolutely no evidence available, then that's how the internal committee inquires into the complaint. They will ask the woman to present her version of events. They will similarly ask the respondent to present their version of the events, and then both versions will be compared against each other, seen where the disparities lie, and then both parties will get an opportunity to be examined by the internal committee and then to cross-examine each other. And that's how the internal committee will arrive at a conclusion as to which version is more credible and can be proceeded with. And obviously, if the charges are proven, then the internal committee will recommend to the employer to take a disciplinary action against the respondent. But of course, if If there are no charges proven, then the internal committee has to recommend to the management that no action has to be taken. So that's how the law is worded. Anyone has any questions so far?
Yes, ma'am. I have two questions. Firstly, as you mentioned that the committee has to comprise of the senior most women employee. So, related to that, if the accused is at a higher cadre or at a higher position in the organization, is it necessary that the senior most woman employee has to be placed at a level above him or at the same level as him?
That's a very important question. See, at the end of the day, it's not important that every single member of the internal committee is someone who has to be at the same level or more senior to the respondent. Of course, if the majority of the members of the internal committee are subordinates of the respondent, then in such cases we typically advise the employers to reconstitute the internal committee specifically for that complaint, to ensure that there are no prejudices or apprehensions when it comes to the functioning of the internal committee. Because as we know, when we talk about justice, it not only should be done but also should be seen to have been done. And so, to avoid a situation where the complainant has a legitimate fear whether the internal committee is acting with an impartial mind, it's important to ensure that the majority of the members are not subordinates of uh, the respondent. So from that perspective, of course, you have to have some checks and balances in place. But just a clarification on the question itself, that if we are talking about the employer of the workplace, and if there is a complaint filed against the employer themselves, then the internal committee cannot take cognizance of that complaint. In that situation, the aggrieved woman has to approach the local committee. Okay, the local committee is appointed by every district. Of course, in reality, you will find that a lot of local committees are not operational at the moment, but I'm not getting into there. The law, however, requires that every district needs to have a local committee. So, where an organization has less than 10 employees, and so they don't have to form an internal committee, or if there is a complaint against the employer themselves, in that case, the complaint has to go to the local committee and not the internal committee. So, that safeguard is already there under the law. Any other questions? Please feel free to post it on the chat box also. But if you want to speak, happy to take up those questions as well.
Hi,
We have,
ma'am.
yes, please
Hi,
continue.
ma'am. Before asking the question, I'll just briefly introduce myself. My name is Vishwas Agarwal, and I am currently working as an associate at Cyril Merchant Mangaldas and Company.
Okay.
Ma'am, so my question is, as you have said in your session that the accused can be anyone. Could be a male or a female. But what we have often seen is that, let's say in case of females, if you go to report to your, let's say, your partner or manager or whoever it is, like about the incident that took place, and you say that this female has done this, guy has done this. So in cases of female, they often get overlooked by stating that, they are just, pulling your leg, they are just kidding, or you misunderstood that fact, because we have that typical mindset currently also, that women can't be a perpetrator to women. That's the mindset that I have also seen. I have also seen in my locality or in my surroundings. So what is your take on it, how to deal with these kind of situations? And secondly, don't my second question is that, don't you think that these sexual offenses should be gender neutral. What is your take on it? Because sometimes a man can also face a sexual harassment from a woman, or from, let's say, from a from a man also. But I have seen myself being being the victim during my college time. I have seen myself, it was said to me that men can always be the perpetrator but not the victim. So, what is your take on?
Thank you so much, Vishwas. Those are really good questions. Yes, my personal opinion is definitely that our laws could be gender neutral. We really need to move on from the mindset that women are the ones who need to be protected. Of course, there's a lot of history around what women have faced over the years, and probably that's the reason why there were laws that were prepared essentially to cater to them. But over a period of time, yes, in my experience, I've seen men going through sexual harassment as well. But most of them resist in terms